one of the judges that is on this next panel. He is not a judge. He's not a judge yet. He would be a good one day. Yes, who just said that? Okay, you win one of those bags back there by Steve. It's got $50 and some other stuff in it.
Well, that's a good way to start off this morning. So anyway, welcome. Glad you are here. I'm sure more people will pour in. It's a little early this morning, but I wanted to just hit on a couple of things, just some reminders for you. Legal credits, if anybody in here needs legal credits, please make sure that you go to the registration desk and sign the form. Other credits will come to you through a survey. So watch your email, and that is how you will apply. Click the links, the appropriate ones that you need credits for, and it'll take you to where you can sign up. You do need to complete those and get them back. Just when you respond, we'll automatically get it back. The DOL, for all the adjusters out there, the DOL will be sending your certificates. What we do is submit their names, but go ahead. There will be, I think, a link that may be included, but go ahead and just complete that survey. That is very important for you to get your credits. Let's see. I wanted to announce the booth winners. We have the staff here at the Hyatt go around and take a look at our booths, and we select 3 winners from them, the participation in the holiday theme that we had. And Rehab Select came in first. Woo-woo. They actually get a free booth next year. Orthopedic Group.
Yay.
You came in second. And then Encore, woo, 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 3rd place. And y'all will get you will get to pick your booth next year over, everybody else. Preference anyway. I think that's about it, but I hope y'all enjoy it. Thank you so much for coming out. It was great to see everybody. I think we've had a great turnout considering all the COVID issues we've had, but thank you so much. And again, if you see our sponsors, our exhibitors, give them a big shout out, because they really, we could not make this happen without them. So y'all enjoy the day. Thank you. We will have door prizes at the end. Please stick around, because everybody likes a door prize. And we're also going to be presenting the proceeds going to the charity. So everybody, we had a great night last night. I hope everybody enjoyed it. Some people walked away with some really nice items. So thank you again for your participation. We enjoyed seeing everybody. I'm going to turn it over to Sean now, and she's going to introduce our first speakers.
All right. We're excited today to have a judicial panel and Mike Fish. Mike and I went to law school together. He has a great blog, a workers' comp blog. For those that don't know, you can go to his website and find it. I'm sure it's fabulous. And one thing that's so important is our judges. And today we're honored to have, along with Mike, Judge Chris Hughes, Claude Hundley, and Jim Patterson. And we know that you will enjoy hearing from them. They make all the decisions, and I'm sure Mike will tell you that. Everything rests with them, so you need to know what they want if you want any chance at all of winning. So, with further
Okay, it's on now. Come on up, judges. All rise. Just kidding, just kidding. So in the past, I'm Mike Fish, by the way. You might have picked up on that. The moderators on the floor, the judges are up where they should be. Normally, when I moderate a panel, I introduce the panelists, but I was told this morning that the panelists would be introduced by the room moderator, and so I was like, well, good. I don't need to put together Well, they were introduced, you know their names, but I don't actually have their bio. I can tell you that I hand selected each one of these judges for this particular panel because these judges are amazing. I find them amazing because they treat both sides fairly. You know, as a defense lawyer and employers, we don't even need the judges to side necessarily towards us every time. We just want a fair shake. And each one of these judges, I could assure you, if you ever have a case in front of them, they're going to give you a fair shake. They're going to consider the facts. They're going to consider the evidence, and they're going to do that. And I know they were introduced before they got up here, but this right here is Judge Patterson. He's out of Mobile. Judge Patterson, you may see his name fairly soon in hopefully a reported decision, a favorable reported decision, because he gave me a really good order last year regarding a UM-UIM case in subrogation that says that we are entitled to recover against a UIM.
I didn't give him anything. He earned it.
So that could be a game changer because we've never really been able to go after that before. And I feel like he interpreted the law correctly on employers UM. So hopefully we'll see something soon that's good for us. Next one is Judge Claude Hundley. Judge Hundley's up in Madison County. Judge Hundley is a former defense attorney, as is Judge Patterson. Maybe that's why I like him so much. We have that in common. But and Judge Hundley, he mediated cases for me before he took the bench. And just as a mediator, he also as a judge, he looks at everything and decides evenly. Even when you're up against local counsel, I never feel like because I don't live there, I'm not being treated equally. And then finally, last but not least, this is Judge Hughes. And he's out of Lee County. And we've certainly wined and dined clients together before you became a judge. Thought of you last night. I took out some clients last night that we took to dinner together before. I haven't actually been in front of Judge Hughes yet as a lawyer, but we were just talking. I've just had a few cases assigned to him, so I'm excited. I know that also a former defense lawyer, obviously, if we were wining and dining clients together. But so that's the best bio I can give you off the top of my head. But I feel like this is going to be a great panel this morning. We do have a few topics that we have planned to cover. And then it's my understanding that in addition to this pretty full room, I'm pretty impressed in light of COVID. We also have virtual attendance that put us up over 1,000 people. So a lot of folks are watching this this morning. And then it'll also be available after this. If anyone wants to review it later on down the road, you can tell your coworkers they can sign up, I think, for credit and watch it later after this. So welcome to the AWCO conference. This is a great one. The Department of Labor puts on good conferences. This one, if this is your first time, I hope you enjoy it, and I hope you'll come back. With that, we'll go ahead and get started. I'm standing here so I can be on the screen too, because we are on the screen. And there's also, okay, there goes the window. Let's start out. When I'm moderating a judges panel, this is my chance to ask questions that I just always wanted to know as a lawyer, and hopefully you'll want to know the answers to these questions too. But Judge Patterson, we were talking earlier this morning about attorney representation, and you know, so there's different levels of representation that you may have seen from the bench. And meaning, you know, different lawyers bring a little something different. Sometimes they don't bring anything at all. So 25590A says that a plaintiff's attorney, well, actually the plaintiff has to apply to have representation. They actually have to apply and ask the judge, and then the judge actually has to approve that representation. That's the only way the plaintiff's attorney gets paid. So it's an application process and an approval process. I've always wondered, is that a rubber stamp, or when you get that application, do you look at the qualifications of the attorney, and do you look at whether or not they should be representing the plaintiff?
It's a rubber stamp.
That's what I thought. That's been my experience.
I don't feel like it's my place to deny somebody representation that they've chosen. Now, if the lawyer proves to be incompetent later, then there's, you know, it's a different story. But
okay.
for me, it's a rubber stamp.
We may come back to a different story, but for now, same question, Judge Hundley.
I agree. It's a rubber stamp. They've chosen them at that stage, and so I don't interfere at that stage.
Okay. Do you feel differently, Judge Hughes?
No, I don't. In fact, I've noticed, and I don't know if y'all have, but I think people are bypassing that more and more these days. And if they do, to be honest, I never give it a thought.
Okay. And if they do bypass that, because the statute says that they're not entitled to a fee if they're not officially involved, if they don't have that rubber stamp. Has that ever become an issue? Raise your hand if that's been an issue as far as getting a fee. No issue? Okay. All right. So this kind of goes into my next question. I was going to ask you if you did look at the qualifications and if you did approve them based on those qualifications, did that cause you to defer more to their opinions when it came time to settle a case? If it's a rubber stamp, then maybe that answers my question. But that aside, when you do have an attorney, and I'll start with you, Judge Patterson. When you do have an attorney representing the plaintiff and they're settling a case with you, and they're representing, I've gone over this with my client, I, as his representative, feel that this is in his best interest. I know judges have the duty to also make an independent determination of, we call them best interest hearing. Do you feel like you should defer to that attorney since they are representing the interests of his client, or do you make a separate decision?
I generally listen to what they have to say, and I have shut hearings down and say, no, we're not settling this today. I've done it multiple times. A lot of it has to do with Medicare set aside, paying liens and things like that. And I have taken an active role and saying, no, it's not in his best interest. Come back with something else.
Okay. Same question for you, Judge Hundley.
Similar. I have had some, usually in the settlement portion, I can tell when they get started if they know what they're doing. And so I'll ask a few key questions to find out if they're really on top of it. If it looks completely off, I'll just tell them, no, we're not going to take this. And usually the defense lawyer picks up on it, and because it's one that's been brought usually from an adjuster, they acknowledge that they had nothing to do with it either, but they'll look into it and see if they can get something that the court might accept. But I've not had many, but I have had some that I've had to do that.
Okay. You feel the same way, Judge Hughes?
Yeah, I've done that a few times. And I guess I've never perhaps per se said, I'm not going to approve this. I always extend it and say, maybe you need to go back and explore this part of the settlement or that part of the settlement and come back. Okay.
Now, Alabama's a little different. I know in some states, and we've looked to make this change in Alabama, it hasn't happened. But Judge Hundley, there could someday be a statute that says if they're represented, then you do defer to them. And if that happens, does that change your opinion on the application process? Does the rubber stamp turn into more of a, you take that part a little bit more seriously if you're going to have to defer to their opinions later?
I think what puts us in a position to, after I'm like everyone else up here, previously I never paid very much attention to the rubber stamp, even as a lawyer. Then after you showed there would be a question, I did a little looking into it. It appears that the way we got to the rubber stamp was sort of a trade-off because of the fee side going to be so low that the legislature wanted the people who did this work to realize that they would not be charging what the normal plaintiff structured fee was. If that was one of the things, the other side is because of the trade-off that was done in the negotiations to allow it to be somewhat of a strict liability thing when comp began to flourish more and they, and set all the other barriers. It appears that they were saying, okay, we need folks who actually know how to make these things happen. So I think if we're going to ever head in that vein, then we're going to have to look at all of the things that lead to that, because I think they all feed off of each other.
Okay. Okay. Let me stick with you with one more question, Judge Hundley, because you did mention the low fee. And of course, it's capped at 15%. That's the most they can get. They're not necessarily entitled to 15%, but that's the most they can get, right? So what about a situation where you've got a catastrophic case? There's no question. They started getting their weekly benefits from day one because the employer doesn't deny that it's a catastrophic case. Plaintiff's attorney gets involved. They either settle for what they're already getting, or you have a hearing and then the hearing says they're PTD, which was never in dispute, and they continue to get those benefits. that attorney tries to get 15% of the present value of something that he really had nothing to do with getting. Have you ever had that situation?
Have not had that one, no.
Any idea how you would approach that?
Well, I usually try to make sure the plaintiff's lawyers understand, because most of my discussions with them occur with the medical side, where there's no provision for them to get that. And so whenever I see that coming, because I usually meet with my comp lawyers on a status conference probably every 3 to 6 months to see where they're going. That way they usually see where this case is headed, and usually they settle because of that, because they've all met together and I've realized what their claims are, and they're educating me at the same time. All that said, to simply say this, with that, they usually are seeing where it's headed. And so therefore, those type issues are working themselves out through the course of this. They realize that they're just so far they can go, and I'm not going to go beyond whatever the statute says they can do anyways.
Yep, that's been my experience. They usually do get worked out. Judge Hughes, if a settlement is presented to you and you don't agree with it, even though they're represented, you don't agree with it, even though the plaintiff's attorney is saying, I think it's in their best interest, the defense lawyer is on board, the plaintiff's asking you to approve it, but it just doesn't pass the sniff test for you. When you don't approve it, do you tell the attorneys, I'm not going to approve this, but I would be inclined to approve this, and kind of give them an idea of where they need to come in at?
I have not yet, which is not to say I wouldn't ever. I've not a figure or a sum certain, but what I have done is point out where I think the rub is, so to speak, where the problem is, and say, if you would address this, or I think this needs more exploring, and it has as much to do with the complexity maybe, or the unsophistication of the client, just to make sure, because there may be good reasons why this figure is not any higher than it is, but I want to make sure that client himself really does understand what he might be entitled to versus what he's agreeing to.
Have you ever had a case where you did not accept the settlement and then ended up trying that case?
I really don't think so.
Okay. Judge Patterson, if you have that situation and you don't approve the settlement, do you encourage the parties to mediate?
I'd do more what Judge Hughes just said. If there's a problem in a settlement, I usually articulate it. I have a problem with this. You guys need to go back and check this out. And once you give me the answers that I need, then we'll do it again. Okay. I've never gotten past that, which the lawyers generally, like I said, it generally has to do with Medicare set aside, some kind of lien or something like that.
Gotcha.
So I haven't had this situation.
Have you had a situation where you didn't approve the settlement and then it proceeded into litigation?
No.
Okay. If that happened, and it may happen in the future, would you hold on to the case, or would you punt that to another judge?
Well, man, you hadn't had the situation yet, but when you think of it, if I'm the barrier to settling and I'm the finder of fact, it would probably be prudent to withdraw from the case and kick it to somebody else.
I've made that argument. I wouldn't make it with you.
You would win it. You would win, because I mean, it's not fair when you're the guy that bars settlement and you're the trier of fact.
Right.
It doesn't, we're supposed to recuse if it doesn't give the appearance of fairness. And I could see where a claimant would go, well, that's not fair.
Exactly right. And so if it does go into litigation, not that case, but let's say another case that you have, a litigated case, do you always order cases to mediation?
Well, let's go outside of work comp for just a second. I've only been doing this judge business for about 4 years. I was defending cases for the rest of the time. And I decided when I was a judge, I wasn't going to order everything to mediate. It was the parties' case, and I was going to let them do what they wanted to do. But then you see some just junk cases come through, and they get ready, and you'd have a case sitting there for a couple of years and go, why haven't you guys mediated this? Well, you never ordered us to. Ding, 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 ding. So now I have a stock mediation order. When I set a case for trial, I set it for mediation.
Yep.
And I have no problem if they mediate it with the ombudsman. It doesn't matter. What I do is I look at who the lawyers are, and you can kind of find who plays nice with each other and who doesn't play nice with each other. And if I've got lawyers that don't play nice with each other, I'll pick a strong mediator, maybe even a retired judge. I'll look at their personalities.
That's funny. My next question is, why do you always assign the mediator in my cases? If a mediator's assigned, and I know.
I'll tell you a secret.
Okay.
It doesn't bother me if I assign somebody and you don't want them, lawyers are scared of the judges. Oh my God, I'm going to make the judge mad if I decide I want a different mediator. You're not going to make me mad.
Yeah. Well, sometimes we just want an ombudsman. Jonathan Berryhill, ladies and gentlemen.
How deep are you willing to go into the background and bona fides of the settlement? And I ask this in the context of several years back, the bench in Jefferson County particularly applied strict scrutiny to closing future medical benefits, which when you looked at the workers' compensation case only made sense. But if you looked at what was going on in the claimant's life, maybe they were behind on the house, or they couldn't feed their kids, or there were other issues at play. How deep do you want to, or would you entertain us going at such?
Well,
Okay, let me repeat the question just so the virtual community can hear. The question is from Jonathan Berryhill, attorney here in Birmingham. Judges, how far do you go into the background and bona fides of the case? Do you look just within the confines of the comp case, or do you look at other needs that the plaintiff may be having, such as house payments, that sort of thing, where it might make more sense for this settlement to happen? It might actually be in their best interest when you think outside the box. Do judges, a raise of hands, do you do that, or do you?
I'm guilty.
Guilty?
I do it.
Okay. Well, what about you, judges? Hundley and Judge Hughes?
I don't let that come into play if it is a case that is dealing with the indemnity part or something like that. And then I'll tell you why I separate that out. When it comes to that, the case has whatever value it has. And if somebody is settling cheap because of that, then that's going to be between them and their lawyer. I do require, if it's something I can't see a lot of, for them to give me an idea of why they're coming in that direction, and then I let them and the lawyer understand, that you're all making sure that this is what y'all agreed on. I have this catchphrase. I say, I didn't come in to wreck your one-car funeral, so I'm not going to try to inject myself, but just realize where you are. There have been some opportunities in the medical closure situation, which I do ask more questions about, where I've done it because of that. Usually when I've had one or two where maybe the people were about terminally ill for other reasons other than the comp situation, and had family folks that they were trying to take care of. And even though because of the nature of their comp injury, they probably needed it open forever, but they realized that they were coming into that junction in their life. That explained it to me. It made more sense. And then in those situations, it has more of a play than, there was no judge in Madison County used to say that boat is not going to be a boat when it sails. So just because it looks real good right now and you get that money, it's not going to last as long as you think.
In those situations, as a follow-up question, those situations, are you more inclined to maybe approve it if there's like an annuity involved where it guarantees payments for X amount of time, that sort of thing?
Something that shows that it's going to be, because they're going to be hit, obviously, with the medical side of it. Those things would continue because it's a lifetime benefit. So to the extent that it'll be able to take care of them and show that it benefits, and then I let them have, they can tell me why they're there. And there have been some, and so, as I said, I don't feel like I'm there to negotiate that. The one that I try to keep on, that I find more out of what John was talking about, is when there are other cases into play, that may be the reason that they are doing what they're doing here. There are third-party suits or their subrogation interest. And so when they explain those issues, that's okay. It makes sense as to why you're doing it.
I got you. So Judge Hughes, same question. Have you been presented with a situation where you had to look outside the facts of the comp case itself?
Yeah, I think you have to just take every case. This is a cop-out answer, but you have to take every case separately because every circumstance is different. But I think one of the reasons we are asked to, or required to approve these settlements is that we can sort of look at it from 1,000 feet in the air. And it's kind of like, I kind of equate it to the pro-ami settlements for the minors. You have to sort of look beyond their desperation of the moment and the down the road, so to speak, purposes of the statute.
Gotcha. Of course, I'm going to switch gears on you. We're all familiar with the Alabama Supreme Court emergency pandemic rules regarding settlement. And right now, we're even in the litigated cases, we can use ombudsman. And we've got a good one over here. Hey, Pat. Pat's out of Mobile. We can use them to actually bring closure to the settlement. And when that happens, we file basically a motion to dismiss. And the Supreme Court right now says, you got to dismiss the case. That rule is good through the end of this year, but there's been some talk about maybe trying to make that permanent. With a show of hands, are any of you judges against making a rule like that permanent? Okay, well, my next question was going to be why, so that does away with that. So yeah, I mean, I certainly hope it's made things a lot more efficient. It does bring me to my next question, because when there is closure with an ombudsman, there's a 60-day right of appeal. It's not supposed to be just a right to appeal, but if there's newly discovered evidence, if there's evidence of fraud, that sort of thing, then they're supposed to be able to get it before the judge. So what a lot of defense lawyers have been doing in order to give them the check immediately is we include 60-day right to appeal waivers. And I don't think that's been addressed by any judge up to this point. Do any of you, show of hands, do any of you feel like a 60-day waiver should not be upheld if they choose to? Okay, well, Judge Patterson, let's start with you. What happens if this gets appealed to you and I've got my really good waiver language that I spent a lot of time on?
And I'll say, it's the law of the state of Alabama. What right do you have to waive the law? Let's say you go rob a bank and the bank gives you a waiver. Hey, we'll give you a waiver, come rob us. You can't do that.
Let me write that down. Judge Hundley, did I see a hand up?
Yes, I appreciate what Judge said, because now I'll use that also. My basic thing was also on pro se people. They might not understand what they're waiving.
Right.
And if I got two good attorneys, I might consider it a little bit more, but Judge just told me, and since I believe in following the law, there's a law now that they've lost theirs. So he killed it for you up north. I'm sorry.
May I assume?
Sorry.
May I assume that my language in that paragraph I worked really hard on that says that if they do choose to appeal, then they have to reimburse attorney's fees and whatnot for the litigation that's involved with that. I assume that's not going to be upheld either.
Probably not.
But the judges that don't agree with the waiver of appeal, would it make any difference if it's a represented party as part of that contract negotiation?
So the question is,
It becomes a contract issue then. But the judge says, the law says the waiver is a right. I think it would take a court case to say what to extent that waiver is standing. That would at least give something to appeal on. So.
that was an answer to the question, which was, does it matter if there's attorney involvement? And the short version is no.
I didn't mean to drop a bomb on your boat. Sorry.
Turn the recorders off.
Sometimes.
You asked. You're not supposed to ask a question you don't know the answer to.
That's right. Well, I kind of knew. I had an idea. We might as well have it out there.
Just incidentally, before you leave that topic, I knew that was going to be asked about the pandemic rule. And our court administrator in Lee County is the chairman of the committee that's always revamping the rules of judicial administration. And she showed me a draft. Apparently it is in the very final stages of being, the language being worked out. So it would appear, and I'm not a knowledgeable source, but that it's very likely to become a rule.
Well, that's great. And will the rule, does it address virtual? Can we still do everything virtually as part of that rule?
That one does not. The only reason I'm on that committee.
Oh, well, there you go.
And so I brought it.
Oh, okay.
I brought a copy of the proposal here that they've sent us out. It has not passed yet. It would be Rule 48 of the Alabama Judicial Rules Administration. It does not address virtual one way or the other, but it does include all the other that you have.
Okay, so it doesn't prohibit virtual.
Doesn't prohibit it.
So if the parties agree.
That's going to be left up to the judge.
Okay, and the ombudsman, I assume, in that situation. Speaking of virtual, let's go back to mediation for a second. If a mediation is ordered, I know I've seen different orders for mediation. Sometimes they order the mediator. Sometimes they order who has to be present. Does anyone here order that the client has to be there, whether it's an assurance adjuster or an employer representative? Does anyone order that?
I have a stock order that just basically says, let me tell it goes back to when I was doing what you do. And I had mediator or adjusters who didn't want to fly to Mobile, didn't want to get involved in the case. And they would make me hire some straw man adjuster to sit there and pretend like they're the insurance company. And they're sitting there totally disengaged, telling me what to do from some office. And they're not sitting there looking at the client, looking at what's going on. And so I have an order that basically says the adjuster over the case with full authority to settle must be present in person, if it's in person, or via Zoom for the mediation. But I make them be there.
Okay.
Because you can't facilitate a decent settlement without. It gets back to what Pat and I were talking about. I can't tell you the difference between a $20,000 case and a $25,000 case. I can't tell you. And you have some adjuster telling you, settle it for this. And anyway.
Is the Zoom part, because I don't know that any of us even knew what Zoom was before the pandemic. Is the Zoom part a new thing? Like the last year, you've started including Zoom?
I'm only going to include Zoom while I have to.
Okay.
I hate Zoom. I think you lose a lot with people not being in the room together. It's just a human to human contact.
Is it fair to say that if you do have an adjuster from Iowa and the defense attorney files something and says, look, this case we don't perceive this case being worth $5,000 and you want us to incur that just to have somebody present, would you give them relief, or do they have to be there no matter what the case?
It would depend on the magnitude of the case. If it's some dinky little case, I got it, but they usually could settle it among themselves. I mean,
and I know code section 6620, which is not part of the Workers' Comp Act, but that's the statute that says you can order mediation. And if you do that, we have to participate. It doesn't say we have to participate with authority. And I know in Madison County that came up. The defendant showed up without, I guess, sufficient authority in the judge's mind, and they got dinged for the tune of a little over $620,000 in sanctions.
Was not me.
No, it wasn't you, Judge. But do any of you feel like if you order mediation that they're not complying with the order if they show up without authority? If that's how obviously if that's how they value the case.
no.
Because sometimes defense, the defense looks at it and says, this is one we're going to have to try.
In my cases would never be mediated at that point. I take a different approach. I massage my cases. By the time I send the lawyers to mediation and comp, where they become the only lawyers that could probably say that I force them into mediation are domestic cases. But civil cases, comp cases, those cases are about money. And so I meet with the lawyers throughout the case, and when I send them to mediation, they want to go. Or they say, Judge, we were better off at mediation. Maybe they can't say it for their clients, but if I order it, they said, if you send us, things will happen. And so I don't run into that problem of them saying, I'll go, but I don't have any money, because I would have met with them. They will tell me if they just cannot settle this case, and they'll be telling me why it is they can't settle it. And if I think they can settle it, I'll tell them why I think they can. And they can use that to go talk to their clients. So I don't get into this thing of, well, you're going to make me go, but I ain't going to have no money, because I already know why you're going. I already know why there is a problem in the case. And if there's a real problem, we're just going to try it.
Right.
And we're just going to lay it out on the table and let it happen. But as I often tell them, you're more happier if you mediate it. I'd like to address the question about the client being there. I don't require that, but it's simply because when I was a lawyer doing this, I never had anybody going with me anyway. I did a lot of third-party groups, so I never had to have them there. They usually sent me with a range of authority and a phone number to call once I got outside my range that was ready, willing, and able. And so I guess because I never had anybody, I really never wanted anybody in there interfering with what I was doing, because they just get to kind of muddy up the water, because saying things unnecessary, and I'm trying to soothe their savage beasts at the same time. And so I just never had to have them there. Most of the cases I send to mediation and comp settle, but it's because we have marched them up to that point, and the lawyer will say, "Hey, judge, we need to go, and we think this will go away there," and they'll even tell me if it, and then I'll even get those that say sometimes they'll say, "Well, let us mediate before we do discovery because we might can get rid of it," and so I'll let them mediate. If they can't, I come back, then I let them do discovery. They tell me why they want to go. And so I'm back to with Judge on Zoom. I'm not a very big fan of Zoom. Simply, I think it's a very good tool that came to us when we needed it and helped us when we had to have it. But lost in that was the interpersonal relationships that lawyers have with each other. And so it's easier to be a butthole on the screen, you know? And so I had you.
With a cat face.
Yeah.
Can I quote that?
Yeah.
I like that. That's my new quote.
And so I try to, if I get them together, usually they are, and when I have my meetings with them, they don't bring clients, you know, I know how they like to do that. I get them in the bag and I say, okay, tell me what this is about. We walk ourselves through. They know I'm an old comp lawyer. They're going to say, all right, Judge, this is my problem. They'll tell me that. And then I say, and I'll ask questions to kind of help them get together on that. And it makes a move. And when I end up trying one, it needs to be tried. And then some of them need to be tried. But those that don't need to be tried, just go away. You know, I don't select the mediators. I let them generally use the ombudsman. My order says ombudsman. But a lot of times they will tell me, we need somebody that knows something about comp. And so they know who they feel good about it. And they usually will make me a suggestion. If they don't, I'll make one for them. They'll say, we need so-and-so for this because we think if they can get us through this, they know enough comp to get us out of this. And they're both there because they've been talking. They've been living this case. They've been going through this case and they realize that the ultimate goal is either settle it or try it. And you're going to have to do one or the other because, as I say, they don't come here to live. So figure out what you're going to do. And they do that. And they just work themselves out like that.
Yeah, and that's true. With a mediator, you absolutely have to have someone that has workers' comp background. It's impossible to bring them together if they don't understand the workers' comp issues. And the Department of Labor right now has an amazing set of ombudsmen with background. Steve's done a good job. John Lewis, a good job of putting together these ombudsmen with legal backgrounds. We've got them on the plaintiff side, on the defense side, and they're very effective. Have I got 10 minutes?
Audience question?
No, I've got 20 minutes. Oh, I've got a question.
For an in-person mediation, would this be for an out-of-state adjuster as well? I think that relates to in-person attendance being mandatory.
So the question is, for in-person mediation, do the outside the state adjusters have to attend in person, or can they attend via Zoom too? Is it the same, basically the same answer?
It gets to, like Judge Guthrie said, massaging the case and watching what's happening. And there are times when it's easier to be a butthole on screen. And so,
let me check the list of words.
Guys, but if you can tell that the adjuster is being a butthole, then that's when sometimes having to buy that plane ticket to fly to Mobile, Alabama will get you that last $2,000 that you need to settle that case. And we know that. And I'm not talking about a comp case. I used to do a lot of work for a big, large insurance carrier that I used to be insured with when I was in the military. And I had this one adjuster and she didn't want to go anywhere. And she would tell me what stuff was worth up in northern Mississippi when I knew what it was worth up in northern Mississippi. And so I have this order and it's named after her. And it's the so-and-so mediation hammer order. And that's the one that says, I'm going to add to it. It's easy to be a butthole on screen. So it just depends on the case. You know,
does she know that it's named after her? Is she entitled to royalties?
I have told every lawyer who handles their business since I gave it up that if you're working with her and you need help, let me know because I can get her attention. It was a bad case. This guy had rods in his back. He had been hit in a car wreck. The lady who hit him her daddy was a county administrator for Rankin County, Mississippi. We were within $30,000 of settling this case. All they wanted was $150,000. I had valued it as a $500,000 case if it went to trial. And I finally told her, I'm not taking this case to trial in Rankin County, Mississippi and getting a $500,000 verdict against me when you can settle it for $150,000. And that was around the time I got elected judge. And she called me a month or two later. She says, hey, you know, I settled that case because I told I was going to withdraw. I wasn't going to try. So that there's a lot of background there.
Well, until it was brought to my attention, I didn't realize how fast we were speeding through this. So there's no way we're going to get through all the notes here. This has been entertaining. I'm going to just kind of cherry pick some of the ones that I think that the crowd will be most interested in. So I want to drop down to IMEs, because I know in workers' comp, we never get IMEs because the employer gets to choose the doctor. So, I mean, the general consensus that I've seen among the judiciary is if we're choosing the doctor, we're stuck with the doctor's opinion. So why would we listen to an IME? However, 25577 says that you can select an IME by motion of either party, or you can just do it on your own. You can select the IME, you select the doctor, I would assume it's a doctor that you're familiar with, whose opinion that you trust. So have all of you done that? None of you have done that?
I don't think so.
Okay. Is that because no one's asked you to?
Nobody's ever asked.
No one's asked? Okay.
Please don't tell everybody that exists, because then we'll be inundated with those.
Well, let me help us out of that. Let me help us out of that. I personally believe that if you're going to ask me to pick a doctor, then my implicit bias may come in, and I'm basically conservative, and I don't think it would be fair for me to pick some, Tim Revels or somebody. They would start looking at the judge going, wait a minute, you're getting into it. I don't think
No,
that's
Tim
a good
Revels, no, that would be fair.
Of course.
Well, I've seen it where the plaintiff's attorney and the defense attorney get together and agree on 3 and present it to the judge. Would that change your mind?
I tell you what I would do. I'd do rock, scissors, paper. And I would just, okay, you give me 3, 1, 2, I'd roll the dice. And that way I made no choice. Do a random number generator or something.
Okay.
I would make no choice.
So in that case, you wouldn't defer more to the opinions of that doctor since you didn't select them. I mean, you did, but you didn't. So you wouldn't give them any more weight than anyone else.
No, I just
Got
wouldn't
you.
select it.
Which would bring us back to you're not going to listen to the IME doctor versus the ATP.
I listen to
authorized
all of them.
Yeah. Okay. Well, so little known rule, 25588 says that we can ask for a jury in a workers' comp case. This wasn't the case until 1992 when we got the 25551 willful misconduct offenses like impairment, misrepresentation, that sort of thing. But now in the back of the code, it says, oh, if you're asserting those defenses, the employer can ask for a jury. And if they don't ask for a jury, the plaintiff's attorney then has 5 days and they can ask for a jury. Now, I would never ask for a jury with you judges. Has any defense lawyer asked for a jury with any of you judges?
No.
Nope.
Has a plaintiff's attorney then asked for a jury with you judges?
No.
Okay.
Nope.
They probably don't know about that rule.
You
Let's
just
not
told
tell
me
them.
about that.
Let's
Yeah,
not
me
tell them.
too.
So
So,
we wouldn't get it in COVID anyway. We tried
Right.
5 years from now.
right.
Yeah, you really get behind.
Well, that's a defense tactic, isn't it? Delay. I learn something new every time I open the code. And last night when I was preparing for this or writing out my list, I noticed something in 255, and it's actually 25581, the right to a jury trial, not 88. I noticed the next subpart. I don't know why I've never noticed this before. It said, court deemed open at all times. Have you ever seen this provision?
Yeah.
Yeah. For purposes of hearing and determining controversies between an employer and employee arising under this article, the circuit court shall be deemed always in session. So is there a hotline if we need you at 3 a.m.?
I sort of educated myself on this in the context of a grand jury, and it goes back to in older times, there were set terms of court. And so I suspect that provision is there in case, somebody had to have an emergency surgery or something. In those cases, you would have to have the court open between the set terms. But if you look now, there has been some later statute passed that universally says the court's deemed to be always open. So it's probably just superfluous.
Is Charlie Drummond in here? I owe you a beer. You were right. Let's talk about credibility, because when I'm preparing for trial, very few of the cases actually get to that point. The facts are what they are. We usually, all the parties agree, the medical records come in. It's not a huge evidentiary battle usually, except maybe occasional hearsay. My doctor told me this, but credibility is key. I spend most of my time preparing cross-examination. I assume, not even just workers' comp, but I'd love to hear a war story from each of you where credibility was the issue and the defense lawyer or even the plaintiff's attorney really did a successful job of attacking credibility where you just decided to discount that witness's testimony completely. Judge Patterson, do you have one?
Yes. It's one of those kind of cases. It was a municipality. Some folks were working in a cabinet shop and somehow I picked up on everybody in the cabinet shop had some kind of a comp claim. And so came time for judgment day for one of them and he comes in front of us and the attorneys do a really good job of, he claims he can't do this, claims he can't do that, claims he can't do the other. Yet while at the same time he can't do any of this, he's crawling up under somebody's house, working on plumbing and doing all this kind of stuff. And they brought the guy whose house he was working on to testify. And I'm listening to this. And I'm sitting there going, dude, you ain't getting nothing. You ain't getting nothing. And then the lawyers asked to submit post-trial briefs. And they submitted post-trial briefs. And before I was able to get the ruling out, waiting for the post-trial brief deadline, the lawyers for the city settled the case with this guy and gave him a buttload of money. And I'm going, I was going to goose egg him because he was lying.
Did you
And
appeal?
You could tell he was, I should have. It's like, so yeah, credibility is everything.
It is, it is. How about you, Judge Hundley?
It's a big issue. I thought about that last night, and I've got so many of them from a lawyer and from the bench. I just tried one recently. Actually, it was being brought by, and I figured he had doing a favor. An old defense lawyer was the plaintiff's lawyer in this case, and so when the lawyer was attacking the credibility, I just saw the old defense lawyer go. He knew the boat had sunk, as it's the biggest issue in comp. I always tell the lawyers, and they know this, especially, just give me the medical records, point out the important stuff I need to read. I usually, if there's a case I got to try on the medical side, I usually read the records myself anyway. And if you'll point me out where I need to go, I'll get there a lot quicker. Because I'll usually know what to look for and I start looking for that. But if you fall back down to the credibility side, where it is, okay, the doctor says you should be able to do this, but you're now saying you can't do that. In this particular case, the person was saying they weren't able to do anything, but they were working, making the same amount of money they were working before the injury and working as many hours, and so they had all those things, but yet and still they were trying to claim. And so it just wasn't, it didn't wash. And so that's where you win your case, is usually on the credibility issue. If you don't have a medical issue, then that's where you're going to have to get the rest of it in.
Totally agree. How about you, Judge Hughes? You got a good story for us?
I don't know that I have a particular war story. Most of my memories are from when I was practicing as opposed to
Yeah, me too.
having been on the bench. I will say this, I was about, as a defense lawyer, 0 and 100 on surveillance ever helping my case out. For some reason, I always had plaintiffs who were, they were too lazy to go lay bricks when they were hurt. They would never come out of the house. I could never get any relief there. But I will agree with Judge Hundley. Practically in a workers' comp case, credibility is the sole determinant, to be honest with you.
Couldn't agree with you more. So I do want to ask this. I know we're getting into 10 minutes, but we've all seen the quote. Anytime a plaintiff's attorney files anything in response to anything, we get what I call the quote, which is workers' comp laws should be liberally construed in favor of the employee in order to advance and effectuate their beneficent purposes. So that quote, it deals with, the statute. If it's ambiguous, then you're supposed to lean towards the employee. But they use it for everything because they see the word liberally construed and they see the words in favor of the employee. And so do you see them trying to use that to say, hey, you got to apply that to the facts? You got to construe the facts in favor of my client. Have you had them try to do that?
Yes, I mean, there's a difference. I mean, they all say that and they all sort of push that. It's pretty commonplace that they sort of take that as to be the overarching theme of the workers' compensation body of law, for what it's worth.
The plaintiff's attorneys have the burden of proof. I mean, even though it's no fault, workers'
Still have
comp,
some proof of that.
they have the burden of proof. That means that if it's a tie, they didn't meet that burden. Does the quote change that for you? If there's a tie, if it comes, the facts of the case make it a tie, does the quote or does anything else dealing with workers' comp, does the tie go to the plaintiff?
That's where I think credibility comes into play. Because if you get there and it becomes a question, then with anything we try, it's the credibility of that particular witness. And it may not always be maybe some other witnesses. So that's where that comes into play, because even I think when you select who come and testify on behalf of your company, you need to make sure you got somebody that's going to make a good presentation for that, because they're going to get attacked obviously by the other side.
Credibility is the tiebreaker.
That's right.
Okay. So we won't really have a tie. Very good. Judge Patterson, I want to make sure
Before you go from that topic, I want to make a point.
Okay.
We talked earlier about having to follow the law about your 60-day thing where I torpedoed you. The quote is workers' compensation laws should be liberally construed in favor of the employee.
That's yeah.
In the military, when I flew, we had this thing called NATOPS. It was Naval Air Training Operating Procedure Standardization. There were 3 definitions: shall, may, and should. Shall was a mandatory procedure. May was recommended, and should was kind of optional. This says should. So I'm following the law if I don't liberally construe.
Well, the code says they shall provide notice within 5 days. But now they got 90.
I'm talking about your I'm talking about your liberal. You're still trying to get out from the other. Next question.
Judge Patterson, you told me that you had a good story, and I jumped around. I didn't skip the topic with your good story, did I?
No.
You got your story?
You talk about how they're wired thing. That was this.
Okay. I just want to make sure we didn't miss it.
That's okay.
Okay,
If you want to hear it.
So do we have any questions from the virtual audience? None? Oh, too many to handle? Just too many? Okay. Is that a question? Are you just stretching?
More of a
Just
comment,
stretching.
Mike. Just some love for you doing this judge panel every year.
What questions for the audience? We've got 6 minutes. Oh, let's start here.
So if you have an employer that has an insurance adjuster or company that the claim is sold, meaning it's old and it's usually what we call a dog claim, bad. And then suddenly the people handling the claim, the employer doesn't know what's going on. And then the employer gets sued for something that they have no idea what's going on. How do you do that?
Let me see if I understand the question. And the question is from Cherie Clark,
It is.
not Sherry, Cherie.
Doesn't matter.
It doesn't matter. From Comp 1. An old dog claim, they get sued. They don't, it's such an old claim, they don't really realize what's going on. How is that viewed by the judge?
I mean, to me,
Was that the one in front of me a couple years ago? I hope not.
I'm just saying, I've seen it before.
I had one this week.
Well, tell us about it.
It keeps getting worse and worse. Basically, it keeps getting sold. They quit paying medical. They get a big build up a big amount. They've even quit paying. This is a PT. They quit paying the weekly benefits, and they build up an amount there. And then some poor lawyer has to come in and say, "Well, Judge, I don't know why this, but we'll explain to this new group where this is, because somebody gets that file." And so we again sitting down had the lawyers, because the defense lawyer realized that I said, you keep this up, you're going to get into an outrage claim, because they were trying to negotiate settlement of the thing on the PT, and had a good plaintiff's lawyer on the other side, and he was building his outrage. I said, now I know him, and what he's doing is he's stacking his bricks, and in 1 minute he's going to put a roof on this thing, and you're going to get hit. And so we sat there and we talked about how can you get past this, because the defense lawyer, he's just picking up the file again, and he says, I'm having to explain this to somebody every few years because of that situation. So I said, why don't you all go mediate this thing? I said, because they're wanting to close the meds. Everybody apparently sees that this thing has a lot of value, but it keeps getting passed on, and somewhere down the line, they're all going to get sued. And so they agreed. And I said, well, back to my point, you need a lawyer who knows comp, because you're going to need the people down there to realize what's on the line. They selected, I think I suggested the name to them. They agreed to that, and that's where they're going. Now, they haven't settled yet. I hope they can, but they just happen. Every once in a while, they're out there. And the lawyers, especially if the lawyer is just now getting it, he's done all he can to try to help them realize these are just benefits you got to pay. And the plaintiff's lawyer is at an awkward position because on the pure medical thing, he can't get any money. So he's going to be, if he's got any sense, he's going to be dreaming up another way to bring his suit where he can get money, and that's what this was leading to.
Is that what you did, Judge Patterson, educate the new group?
I had the mother of all horror stories for that. I'll try to make it brief. Guy had settled his claim years ago. Actually, Judge Jay York had been his lawyer at the time. He left medicals open. He moved away, had a daughter who was an engineer, a son who was a Navy corpsman, nice family. And the adjusters, God bless, they were selling the claim, and they started having problems paying meds, and because of the guy moving and couldn't get a lawyer to handle this. Long story short, I'm convinced the guy was in a lot of pain. He started drinking. He finally died of cirrhosis of the liver because the son testified that he was drinking. They tried to bring an outrage claim. We tried to mediate to get some stuff settled, and the guy died. So the outrage claim died too. But what I would tell you is if you're adjusting these things, do it fairly. If the guy left medicals open, y'all pay the medicals. If you need to try to close them, close them. I get that. But like Judge said, they don't have representation. When medicals are left open and the indemnity is gone, there's no lawyer that's going to take that case. And they're running around begging for lawyers to try to help them. And the lawyers are trying to fabricate things. But what happened was this guy, Mr. Leho, was in pain and he died, and it broke my heart. And I wrote, I was going to help him out and I couldn't. And I'm a conservative dude, but it's that credibility thing. I saw years and years and years more. And God bless whoever the adjuster was, the fourth or fifth one. She had a note in one of her files that said, "Oh, hey, his lawyer's gone to become a judge now. Let's see what's happened. What can we do now?" And it's like, don't do that. Be fair. Be fair. And if you're under an obligation to pay their meds, pay their meds and make yourselves and your employer look good. Because I tell you the truth, if I was an employer and I had somebody handling my comp, stuff like that, I'd sue them.
And if you feel like you've got grounds for not paying them, if you feel like you have grounds for not paying them, you better petition the judge for permission to get a hearing. You're going to need a court order that says you don't owe them, or you're really going to get in hot water,
Hey,
right,
and
judges?
Mike, I don't mean to interrupt you. We did have one more question. It's going to take us over just a little bit, but it's a really good one.
Okay.
Could we get the panel's opinion on whether or not utilization review by a peer physician is useful?
Okay, so the question, we have utilization review in Alabama for medical necessity determinations. If we don't agree that we should be spending $40,000 to prevent rabies from a dog bite, then we can send it to utilization review, get a medical necessity determination. They say, yeah, you're right, that's not medically necessary. But the authorized treating physician bows up and says, no, I think it is medically necessary. They appeal directly to you, which is their right. Do we have a fighting chance with the UR opinion? Judge Patterson, let's start with you.
Yeah, I'm open. I'm always open.
Okay, that's good to hear. How about you, Judge Hundley?
I think your problem comes in as your doctor. And so what I usually do is say, all right, get with your doctor and educate your doctor. I think where I was faced with this so much as a defense lawyer, and I found that the best way for me to try to get that over was, rather than getting in front of the judge and have both of my doctors fighting, was to soft brow my treating physician, which was meet with them, see where they are. I think where the rub comes in that is when you start sending this stuff to a treating physician and they get their back up because they're saying, wait a minute now. You saying, I don't know what I'm doing, so you going off to Minnesota and got this goofball, and he don't know what he's doing either. And so what I usually try to tell them to do, I said, that if you want, I said, this is your doctor, And the plaintiff has every right to sit down and expect that the doctor, see, the big control you have is selecting of the doctor. And they have every, and so you're basically fighting with yourself. So to solve that fight is before you get out in the public arena with it, get them together. The smart thing for the adjuster to do is get this to your lawyer. If that lawyer has, your local lawyer has a good relationship with that treating physician, to go over and meet with Dr. So-and-so and see why he does not like this. See if we can get him to like, and then work it through there rather than fighting it out in front of me, because all the plaintiff's lawyers do is going to sit back and watch you. You're literally fighting yourself.
So going back to the goofball, because the UM doctors are not probably from Alabama. They're not someone you've ever heard of. They're from California, Texas. Not that that makes them any less of a doctor.
No.
You're just not familiar with them.
Not familiar.
What I tell my clients is if it's a situation where you feel strongly about the UR opinion and that the authorized treating physician is just completely off base, and where we see this mostly is like pain management, where they've kind of gone off the rails with the prescribing of the drugs. I'll say, in addition to the goofball, let's select a local doctor that Judge Hundley is familiar with, whose opinion he trusts in that field. And then we've got an IME doctor, well, not an IME doctor, a UR, which is essentially an IME doctor, and a supporting opinion from someone you know versus the ATP. Does that give us more of a fighting chance?
I think it does.
Okay.
The only time I got ever thrown out of a doctor's office as a defense lawyer was when I went in with one of those reports. And I won't name any of the people or the doctors, because they may still be out there. And he literally, when I went doing the deposition, and I actually confronted him with that report at the deposition, and he threw me out. He said, "Get out." He said, and even though I threatened him, I said, "Well, you're going to throw me out, but I am going to have a sheriff bring you to," I was in Marshall County at the time. "I'll bring you to Marshall County, and we will try this case with you on the stand."
He messed
So
with the bull and he got the horns.
Yeah. So we both kind of played chicken with each other. Ultimately, it did settle, but it's a very difficult situation for the lawyer to be in, because you're dealing with both of these folks or your doctors.
Yep.
And it just kind of, and then again, think about this. Once you're through with that case, are you going to ever be able to use this guy again? Because he now says, "Oh, you think you know, and you got old so-and-so out from Minnesota, who if you'd have looked him up, he's on charges for selling pills. And then you're going to do this with me?" So you got to play this thing right. Otherwise, you're going to throw out the baby with the bathwater.
Judge Hughes, what about you? UR doctors versus authorized treating physicians.
I just think it goes back to what we talked about before. Number one, the more information, the better. It's always, that's always the case. And then number two, it becomes a credibility, not in terms of one person being a shyster, not necessarily, but the person who is, doing a one-time evaluation versus somebody who's treated someone for years and years, or the extent to which the IME, made them privy to actually knowing that person's range of motion or whatnot. You just try to look at everything as best you can.
Great. Well,
Can
yeah.
and just because I saw it on your list and just wanted to mention this, I don't know what the other judges feel about this, but a lot of lawyers who deal with me already know this. You had on about the MSAs
Right.
and the approval of those, and then once you set those up, when you bring these pretty much older uneducated people, even younger uneducated people in where you're closing meds, and if MSA has passed on it, I will not approve them unless the administration of those are done by one of those third-party groups.
Okay.
Because it's just crazy to think that this person can make those reports.
Sure.
So it's just easy to go ahead and do all of that on the front end.
If you're doing an MSA with medical closure in front of Judge Hundley, get professional administration, unless you perceive them to be somebody that can.
Capable of doing that
Right.
themselves.
Okay. Y'all feel the same way?
Yeah, I think
Okay.
that helps.
Well, that puts us well over our time, but that was entertaining to say the least. We appreciate y'all. Thank you. Thank you, judges.
Yeah, you too. Here I was. I thought I had really, I thought that was my easy to vote. Here you are on the committee.
I don't care. Where you want to go sit?
I don't care. I'm comfortable.
Thank you.
Yeah.
You're doing a door.
Kyle, are we good to do some trivia questions real quick? All right. For our virtual audience, we've got a couple of questions for you. So listen up.
No, go ahead. Go ahead. I'll chime in. Yeah.
All right. Here is a question for our virtual audience. The third person that gets this answer correct, going to get a prize. So, in the Christmas movie Elf, what name was actor Will Ferrell given when he arrived at the North Pole? In the Christmas movie Elf, what name was actor Will Ferrell given when he arrived at the North Pole? Third. We're calculating the results. Hold on. And if you miss putting your business card in, please put your business card in with Jessica. Eleanor Smith, congratulations. Okay, one more for the virtual. From the movie, It's a Wonderful Life, what is the name of the angel who helps George realize what a wonderful life he has? A little tougher one, probably. From the movie, It's a Wonderful Life, what is the name of the angel who helped George realize what a wonderful life he has? 5. Number 5, correct? Number 5.
Our winner is Rebecca Webb. Rebecca Webb.
Rebecca Webb, congratulations. You are our winner. All right. So we are about to get started with our next presentation. So we will, oh, sorry. For our in-person attendees, we also have a door prize ready. $25 cash. Oh, Lord, my glasses are over there. Okay. No, I don't have.
Troy Corbett, Alabama Power.